Over the past month, I've been following the case against Steven Schwartz and Peter LoDuca, the lawyers who used raw ChatGPT output as the sole form of research to defend a client, and I put research in quotes. The case isn't about whether or not a lawyer can use output from an AI engine. It's about using that information without checking for accuracy in the output. In this case, no confirmation of the actual cases being cited was done. The defense team wasn't even aware there was an issue until the opposing counsel sent back a response to Schwartz's filing that they, the opposing counsel, could not find cases referenced in the defense documents. Even then, Schwartz and his team ignored the evidence that they had submitted fake cases as a defense and proceeded with the trial. Judge Castel, the federal judge in the case against Schwartz and his team, released his findings last week, blasting Schwartz and LoDuca for their complete lack of adherence to basic gatekeeping to ensure the accuracy of their court filings. This isn't something that is a nice to have. It's actually an existing rule called Rule 11. Here's a direct quote from the judge on Schwartz's team's disregard for the law. In researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias, and databases such as Westlaw and LexisNexis. Technological advances are commonplace, and there's nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. Rule 11. Peter LoDuca, Stephen A. Schwartz, and the law firm of Levitt,o and Oberman, P.C., abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, then continued to stand by the fake opinions after judicial orders called their existence into question. I'm going to pause here for a second to let that sink in. A federal judge has stated that it's perfectly fine to use output from an AI engine as part of your research, but you have to check the output for accuracy. For most of us in tech, that's called common sense. It highlights the point that the average layman, when using ChatGPT, doesn't understand the basics of how it works and how the output is generated. Schwartz is no dummy. He's been practicing law for 30 years. We can assume that he's been around the block a couple times in those 30 years, and yet he professes that he was tricked by ChatGPT, that he had no idea that the output could be generated from non-existent cases. If we are to believe him, and I do actually believe him, that doesn't make him stupid. It makes him lazy. The egregiousness, as explained by the judge, is not that Schwartz and LoDuca used ChatGPT as a tool. It is that when confronted with proof that what had been provided was false, they stood by their original filing. Some might say this is further proof that AI needs to be reined in. I disagree. This is not a case against ChatGPT or the use of AI. It's a case against using content without verifying its accuracy. Plain and simple. They were not fooled by ChatGPT output because they never verified a single thing that was output as a response. People were lazy. Don't punish the technology for the human condition. I've put a link to Judge Castel's findings in the resources section of today's episode at 505updates.com. It's well written, thoughtfully organized, and is not mired in legal jargon. It's well worth the read. Thank you to my friend Joel McMull for sending me a copy of Judge Castel's findings. This is Mark Miller reporting in from New York City, just a couple steps away from the Supreme Court.